Well, welcome back to TuckerAllen Live. I'm Scott Trout, and I'm moderating, and happy Friday. We're once again joined by TuckerAllen attorney, Kevin, up in the Kansas City area. Welcome.
Thank you so much, Scott.
Hey, let's talk about I guess it'll be a sensitive subject today, and it's always interesting, and that is, what do you do if you don't trust your son-in-law or a spouse of a child? That's always a difficult one to talk about or actually do anything about. Imagine someone has to really, it's like a prenup. How do you approach that subject with your fiance? It's one of those really delicate things. And keeping in mind, everyone, and make sure to tune in and next week and every Friday at 1 o'clock, where we do this every Friday for about 10-15 minutes. So Kevin, let's talk about it. What kind of estate planning should someone consider? Let's just say they have some questions, they have some issues, and they're worried about when they pass, what happens to their stuff, their money, their things, if they really don't trust their child spouse. What should they do with estate planning?
Sure. So this is, this is definitely something that happens a lot, right? You don't get to choose your child spouse. So sometimes it might not be maybe quite the person you want it to be. So this is a pretty common scenario that we'll run into. So whenever this is the case, most often what we want to do at that point is we want to create a trust for you to distribute those assets to your child. And so the reason being, we'll kind of get into more here in just a second, but like we talk about all the time, a trust is much more modifiable. There's more things you can do with the trust than with just a will. So with a will, that distribution to your child is just going to be outright at the time of your death and just go straight to them. And unless your child's really on the ball about protecting that money, it's not going to be protected. But with the trust, we can add some things in there, and there's some things that we can do that are going to go ahead and provide that level of protection without making your child really have to put in much effort.
We mentioned in our virtual town hall this past week, we talked about the importance of not just a will. Everyone thinks, well, I've only named my child to inherit, but it's this trust really gives you that flexibility. I'm really curious more to talk about, how do I leave inheritance to that person? Let's say it's my daughter, and I don't trust her husband. I never did. We never got along, and I have some real concerns. I mean, we've talked about in the past how to think about remarriages when you get remarried and you take care of your kids, those types of things. And this is a little bit different. You're not necessarily planning to kind of avoid a spousal necessarily inheritance, but this is your heirs, your child's new spouse. So let's talk a little bit more about the trust and how it's really flexible and it's the best tool.
Yep. So every trust that we draft here, whenever the money's going to a child of our clients, we're going to make sure that it's only going to that child or then that child's children. So we're always cognizant that, hey, we're not going to be giving money to the spouse unless our client specifically tells us, yes, I want you to account for this person in my estate plan. Then obviously we will. But so the reason that a trust is great here is because we don't have to give that money then, that inheritance, to the child outright. We can create a thing called a lifetime trust. And then the money at that point, on the passing of the grantor, that this parent that has thinks that they don't like the son-in-law or whoever is too much. So what they can do is they can create a lifetime trust within their trust for their child. So whenever they pass away, what happens then is that inheritance moves into this lifetime trust. Let's go ahead. Let's make the child, let's make the grantor's child the trustee of that. If you trust them, and know that they're going to do what you want, go ahead, make them the trustee. Now, this asset is sitting over in this lifetime trust that only has their name on it. It's never getting commingled in with marital assets. It's in a separate account. It's on, it has the financial advisors investing it for them, not with the rest of their IRAs and everything else. So it's not a marital asset. It's outside of that. They're the trustee of it. So they're the only one that can pull money in and out of this trust. So that's a really great way to protect it. And then, let's say maybe this child, you have concerns because you're like, well, maybe they aren't the best with money and maybe they just be pulling it out and handing it right over to their spouse, blah, blah, blah. You know what? Then in that case, let's find a corporate trustee, that can handle this for you. And let's make this corporation, a trust company, whoever it is, let's make them the corporate trustee of this lifetime trust. And then, we don't have to put really severe restrictions on them being able to use the money. But they do have to go to the corporate trustee every time they want to use it. And that corporate trustee can look into the trust document and say, yes, this is good. You want to buy a new car? That's fine. We can give you the money for that, or whatever it is.
Yeah, I mean, we talk about it, and it's such an interesting, I know firsthand, how it works, and it does work wonderfully. I'm familiar with someone who received a lifetime trust, and her father did not trust her then husband, and made sure that upon his death, it went. She started taking some distributions, and she was smart about making sure that she didn't commingle it. Got remarried, and then did a prenup. To make sure that there was no interest in anything that she was to be taking, which leads us into that question about, which I love the idea of how flexible you can be with a trust. I always think there was a movie about something about a millionaire where he inherited this money and he had to give away a million in order to inherit more. That was the terms of the trust, right? It's an old 70s movie, right? But that's the point, is you can require so much of your child to enter in something like a postnup in order to get these funds, something to that effect.
Yep, absolutely. So let's use this kind of hypothetical again. We already know who the son-in-law is. We already know that the grantor doesn't trust the son-in-law. Okay, that's fine. Let's go ahead and put a provision in this lifetime trust saying, hey, for you to be able to inherit any of these assets, to get any distributions whatsoever, you have to go get a postnup from, from a different attorney. You got to go get a postnup, and it has to say that your husband is waiving his, right to this inheritance because it's just yours. So you can go ahead and do that. And I think it's a great tool because it's not making your child a bad, they're not the bad guy here. And you know what? You've already passed away. So who cares if that person's upset with you? They can be upset with you, but your child can go to their spouse and say, Dad, really, this is what he did. So there's no way we can get around this. We got to go get the postnup. If that person wants to be mad at you at that time, that's a non-factor. So I think that's another great tool as well.
And I think the fact that they may get upset is the very reason why you did it. I mean, that's the point. They have no interest in this money. It's inheritance. It's not theirs. And if they are upset, then good for them to create this provision, because that's what they were trying to avoid. And I think that's why I think when we talked last week or this past week about in our virtual town hall about planning and estate planning and wills, that the will does something, but it's really not the full complete picture. Where the trust, as you suggest, you just have so much control, and the provisions that you want that makes everyone's case unique, meaning that there may be individuals that, like, yes, I absolutely trust, my son-in-law, and I'm not concerned about it. But then you can be, controlling in some other fashions about how you want money divided or used. But I do see it, and I think you do spill over into some marital divorce law in terms of making sure that they don't commingle it to create marital property. Now, it can be used, obviously, when you're talking about spousal support because it is income. But I mean, it's not something where, as me, I'm the creator of the trust. I'm not going to be concerned about what happens if they get divorced. I'm just going to be concerned about him getting control of the money and wasting it. So, it's a great thing. And obviously, this is a thing where they come in with you, they have a consultation, and you go through all the options, right?
Absolutely. Yep. They come in, talk to us. We're going to talk through the options. We're going to, we'll kick it around on our back end too with some, talk to some other attorneys, talk to the paralegals. We're going to make sure we get a full picture. We're truly are trying to do our best to have a team effort here with the things that we do. And if, we might be talking to the financial advisors as well, or talking, if there is going to be a corporate trustee involved, I'm definitely going to be on the phone with the corporate trustee, making sure, like, hey, is this language what you want to see? Are we doing it right for you? We didn't really touch on this as much, but we can, in a situation like this, we can put stipulations on what the money is used for. We can say this is for educational purposes, or, if you're buying things with this money, it needs to be only in your name. There's ways that we can do this. So there's a lot of options with the trust.
Yeah, I think so. I think it's really creative, and I think that's the whole point, is to have it's the best 1 hour of your time to talk about. And this may not be applicable, but what it can morph into is a conversation about the powers of a trust. Meaning that you suggest, okay, maybe you trust the child or the children, but maybe we've talked about this in previous Facebook Lives, and that is you may have an immature heir or son or daughter. You want to do something different. They're not ready if they're inheriting a substantial amount, or they may have a drug problem or an alcohol problem, a gambling problem. Trusting someone aside, again, that's the wonderful wonderful thing about doing the package of a will and a trust. So Kevin, thanks as always for a real fast snippet of information to kind of bring this to life for everyone. I appreciate your time today.
Absolutely. Thank you so much, Scott.
Well, check them out at TuckerAllen.com if you want a consultation. They have offices in the St. Louis area as well as the Kansas City area. You can schedule a consult online. You don't even have to pick up the phone. You can go to TuckerAllen.com, schedule a consult. You can do it via Zoom, via phone, or in person, whatever's comfortable and appropriate for you. So continue to tune in every Friday, 1 o'clock Central Time, right here, same place. Follow us on social media and check out all of our previous virtual town halls. You'll find out information, a lot of resources on their website at TuckerAllen.com. So until next Friday, 1 o'clock Central Time, have a great weekend.